Hello again, everyone. It is Rob Ryder on Tuesday, February 4th, 2014. I'm going to talk about some road trip blues. Them damn traffic tickets. Getting stopped on the side of the road. Real buzz killer. So what you do? Well, you might put in your appearance and motion to see their last, because you would be pointing out their errors. And we'll talk about that. So I'm Rob Ryder. My email address is courtofrecord@aol.com. And my phone number is 616-712-6179. A lot of people like to leave comments and stuff on the videos, which, if that's what you're going to do, that's fine. But I don't respond to them. In fact, I don't read them. If you want to talk to me, you need to email me at courtofrecord@aol.com. And if you just want to email me to tell me I'm incorrect, well, save your time. Because I may just write something to piss you off, so you spend 6 hours writing something back that I'm not going to read. So, we don't have to agree. This is my opinion on stuff. If you think that they're all corrupt and there's nothing you can do, and oh my God, here we go, waiting for the end times, more power to you. Go buy some more freeze-dried food. If you can donate, I would really appreciate it. Two ways to do it. My PayPal account is my daughter's name, Ashley, A-S-H-L-E-Y, Rytlewski, R-Y-T-L-E-W-S-K-I, @gmail.com, or the old snail mail, Robert Rytlewski, 10955, 14 Mile Road, Rockford, Michigan, 49341. At least I think that's my address. It's the one I use. I don't know if it is or not, because we just can't tell anymore, as we'll see. They may have given you an address that you don't know about. They may say that you're actually, in my case, Rytlewski, Robert Allen, and we don't know who Robert Rytlewski is. We don't have him in our books. We got a Rytlewski, Robert Allen, but you didn't say that was you, so we're not going to give you his mail. We're not going to give you the official post office mail. Okay, so about appearances and motions. Again, let's read what it said about an appearance. This is out of the Michigan Civil Procedures book. Rule 2.117 says, appearance by party. A party may appear in an action by filing a notice to that effect, or by physically appearing before the court for that purpose. Okay, now it doesn't tell you where to file the notice, and it doesn't tell you where to appear for the court. Well, it looks like you file your notices in Michigan with the county clerk, proper case county clerk, and the court. The only time that it may be meeting that you can actually get to it would be like on a motion day, because that room they send you to where you think you're sitting in court, that's theater. It's not the court. I did a video on that yesterday about motions, motion day, something or other. Part 1 and part 2 was a two-parter. But the thing is, so you could physically appear before the court. That doesn't mean go to the court window. No, it doesn't mean that. And filing a notice doesn't mean to go to the window that says Superior Court or 16th Judicial Court or 34th Circuit Court. No. You got to pay attention to what it says. It may say to go to the office of the clerk of the court. Well, the office of the clerk of the court is different than the court. You got to go where it says to go, and you may have to get the local rules for this, and I'm sure we'll get it figured over the next little bit, but we're just going by what it says. You got to appear. Why do you need to appear? Well, filing an appearance without taking any other action other than filing your appearance, so without taking any other action towards prosecution or defense of the action, neither confers nor enlarges the jurisdiction of the court over the party. An appearance entitles a party to receive copies of all pleadings and papers as provided by some other court rule. In all other respects, the party is treated as if the appearance had not been filed. Okay, that's huge. You're not going to get the papers and pleadings of the court case unless you file an appearance. Because, number one, that's going to make you like the attorney of record. Right, so now you can converse with the other attorney of record. They got a record of who's involved in this case, who's representing who, and you're going to be representing the defendant because the defendant isn't you. It may be your business. It may be, looks like it's you, but it isn't you. And so if you're not the attorney of record, then they would still send papers to the parties, and the party's the defendant, and the defendant's not you, and that defendant could very well have a different address than you have. And so you wouldn't get the mail, so you're not going to find the certificate of pendency that would go with a court case that says, hey, we got a court case going on. You may see a notice of lis pendens, or a lis pendens, a notice of suit, in a court or in the Register of Deeds, but you didn't get the suit. You didn't get the suit because you didn't file an appearance. Because you're afraid it's going to give them jurisdiction over you. Well, if you don't do it and you don't get the paperwork, they're going to get a default judgment and take your stuff. So to start with, you need to file an appearance so you can get the paperwork, and then you can decide what to do. Because you really haven't appeared or given the court jurisdiction until you answer the charge. And before you answer the charge, you can motion for a more definitive statement. You can motion to find out if the court has jurisdiction. You can motion to say that the plaintiff has asked for, has not stated a claim upon which relief can be granted. All sorts of motions you can do without putting in an answer. And until you put in an answer, you've not given the court jurisdiction. That's the way I understand it. I could be incorrect. And another important thing, defendant not personally notified. A defendant over whom personal jurisdiction was necessary and acquired, but who did not in fact have knowledge of the pendency of the action, may enter an appearance within 1 year after final judgment. And if the defendant shows reason justifying relief from the judgment, and innocent third parties will not be prejudiced, the court may relieve the defendant from the judgment, order, or proceedings from which personal jurisdiction was necessary, on payment of costs or on conditions the court deems just. What that's saying is, again, may enter an appearance within 1 year after final judgment. Well, I don't think they ever give a final judgment. They give summary judgments. They don't give declaratory judgments. They give a summary judgment. It's the midpoint judgment. And while you may have shown up in the courtroom and given them jurisdiction, if you weren't personally notified with the proper summons, then you can bring, this is the idea of what you're bringing up to the court. I wasn't properly summoned. Well, how would you know if you're properly summoned or not? Well, you would read your civil procedures. Under summons, where in Michigan it says, and this is for a civil procedure, on the filing of a complaint, the court clerk shall issue a summons to be served as provided by yada yada yada. The summons must be issued in the name of the people of the state of Michigan under the seal of the court that issued it. That's the first thing you look at. You look at the summons you were given, and you make sure that it conforms to what the frickin' law says it has to. If not, you weren't properly summoned. Doesn't matter if you walked in and gave them jurisdiction by showing up. That shit goes out the window when you say, hey, I wasn't properly summoned. You got a frickin' procedure. They didn't follow a procedure. Okay, so here's an example of what's not correct. All right, this is for a foreclosure. This isn't in Michigan, but it doesn't matter because look at they don't have any file stamp. This is what the defendant got. Serve the defendant. Well, who they're calling a defendant. Although in the court case, on the complaint, that isn't the defendant's name, but they're going to serve this guy. No file stamp. No amount claimed. You were summoned, requested to file an answer. In this case, or otherwise file your appearance in the office of the clerk of the court. Tells you, you need to go put your appearance in the office of the clerk of the court within 30 days after service of this summons, exclusive of the day of service. If you fail to do so, judgment or decree, yada yada yada, default against you. So if you go put in your appearance, again, you're not giving them jurisdiction. You're not even agreeing with this. You're going to go put in your appearance so you can get copies of the frickin' court case that they've put in against you. But if we look further to the sheriff or other process server, right, there's no date of service. There's no witness. This is where the clerk signs there's supposed to be a witness. There's no witness. That's page 1 of 2. Well, let's go look at the other page. Now this is where I got in trouble before. Forget that this is on here, this defendant, because on the one that went to the defendant from page 1, on the back of his page 2, they're all blank. I certify that I served the summons on the defendant as follows: by leaving a copy of the complaint at the individual defendant personally. Did they give one to the defendant? Nope, they didn't say they did. Did they leave one at his house? Nope. And on his corporate defendant? Nope. Other services? None. Service fees? None. There was nothing here. It's all blank. Everything on the back is blank. Blank, 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 blank. There's not a thing on the back of his. There was no summons. There was no service. Well, you can motion to the court to say, hey, I wasn't properly summoned. And I got some motions I want to put in about what happened in the court case. And according to the rule, you can do that up until 1 year after final judgment. And I'm just saying, I don't believe that you're ever going to get to a final judgment, because they only give summary judgments, and there's one more after that called a declaratory judgment. And so if you show reason justifying relief from the judgment and an innocent third party will not be prejudiced, so let's say you were in a foreclosure and the house is still available, well, there's no third party involved yet. But let's say you were in a foreclosure and now they've sold the house to somebody else. Well, they're not going to give you the house back, because that would, that's going to affect an innocent third person. It doesn't mean they won't give you the value they sold the house for. You're just not going to get the house back. Again, that's how I read it. None of that has a damn thing to do with the road trip. We're going to get to that now. But again, I'm just pointing out why you need to put an appearance, and that you would use motions in place of demur. You would use a motion. And you can also put in things like emergency motion to point out indirect contempt of court, because they're suing in the name of a fictitious person. So you would contact the other side. The thing about the motion thing is, first of all, you're supposed to contact the other side and try to settle out of court. Go to your brother first. Hey, brother, the other side, you got this plaintiff that's claiming they're going to foreclose on me in this court case. I need a copy of their certificate of good standing. Right? You don't need to go get it from the Secretary of State. I need a copy of their certificate of good standing. And they're going to say, well, I'm not going to give that to you. Okay, well, fine. And then I'm going to go to the court and put in a motion and compel you to give me a copy of their certificate of good standing. Because if they can't give you a copy of the certificate of good standing, then that means that plaintiff is a fictitious plaintiff. And it is contempt of court to sue in the name of a fictitious plaintiff. That's what I'm going to tell the court and let them decide. Right? That's their job. I'm just pointing out, hey, who the hell is this plaintiff? They don't exist. There's no certificate of good standing. It's a fraudulent plaintiff. And I don't need to get their certificate of good standing. I need to ask their attorney for a copy of their certificate of good standing. And when he doesn't provide it, then I motion the court to compel the attorney to give me a certificate of good standing, or why they shouldn't be found in contempt of court for suing in the name of a fictitious plaintiff, and then sit back and watch the fireworks. So let's go look at Road Trip Blues. So where are we going to start? Well, let's start with this one in Michigan first. I got a call yesterday from a brother here in Michigan. I had done a video before based on this document right here, which is what they use in Michigan is the Uniform Law Citation. That if you were to get stopped for a traffic ticket, this is what they're gonna fill out. And you get down to this part here. Got the complainant's signature and the officer's name printed. Well, the officer is the complainant. All right, he's the one that pulled you over. And so apparently what normally happens is, that these are all computer generated now. They're not handwritten. So it's going to put in here the officer's printed name, But it's not going to give his name. It's going to give an initial and a last name. And then for the complaint signature, I believe the same thing, an initial and last name. So, right, the question is, did the officer sign the instrument if a computer generates in the complaint signature box an initial and a surname? Because, first of all, forgetting that, let's say that it did, we still don't have the officer's name. Right? You don't have a initial for a name. You have a given name and a surname. What's the full name of the officer? You can't put like Trooper TPR P. Simmons, right? You would put Peter Simmons, whatever the guy's name is. They want the officer's name. His name isn't Trooper. It may be a title, but it's not his name. And then, he should sign his complaint. If you don't put pen to paper on this thing, let's just think about this, right? Well, how easy would it be to steal somebody's identity? Pretty damn easy. Even the Indians had to put a mark behind their name on a contract before they were a part of the contract. So that was, what I was saying, and this guy talked to a court administrator who said, well, no, he said, according to a certain rule that we'll look at in a second, that is considered when it prints out on the ticket, that's considered their signature. It's electronic signature. Okay, that's what they say. Now, let's really quick, I have an example of an electronic signature here. I just remember where it is. There it is. We'll talk more about this in a minute because this is goofy. But right here is an electronic signature of a judge. Right? It looks like a signature. It's not printed with an initial and a name. It's a signature. Somebody signed it. Although the signature goes to Flood, Betsy. See how they got the surname, given name. But there is no Flood, Betsy. There's a Flood as a judge. There is an Elizabeth Flood. All right, who the hell is Betsy Flood? Flood, Betsy. Who is that? And anyways, that's her electronic signature. Right? It's not Flood, Betsy printed here, and then Flood, Betsy printed here as the signature. No, it's scribbling for the signature. But the administrator told the guy, said, no, Flood, Betsy, or whatever the guy's name is here. And again, up here, just computer generated, that's the signature. That didn't sound right. To me, I said, that don't really sound right. Let's look at the law again. All right. So he was basing it on. He told the guy if you go to Michigan Compiled Law 764.1e, it will say in there that it talk about them not needing to sign it. That's already signed, right? It's okay. Well, let's go read this thing. Well, the first thing it says is for the purposes of section 1A through D in this chapter, right? We're doing this to fulfill 1A through D or whatever it takes. A complaint signed by a peace officer shall be treated as made under oath if the offense alleged in the complaint is a misdemeanor or ordinance violation for its maximum permissible penalty does not exceed 93 days in jail or fine or both, that was committed in the signing officer's presence or that was committed under circumstances permitting the officer's issuance of a citation under 625A or 6728 Michigan Vehicle Code, yada yada yada, if the complaint contains the following statement immediately above the date and signature of the officer. I declare under penalty of perjury that the statements above are true to the best of my information, knowledge, and belief. A peace officer who knowing the statement is false, makes a material false statement in a complaint signed under subsection 1 is guilty of perjury, a felony punishable by imprisonment for not more than 15 years, and in addition is a contempt of court. Okay, all I read in here is a lot of things about a guy signing something. Complaint signed by peace officer. The following statement immediately above, the date and signature of the officer. Peace officer who knowing the statement to be false makes a materially false statement in a complaint signed under this subsection. In other words, there's nothing in here about this guy not needing to sign the damn complaint. What it says is he doesn't need to swear it under oath if the instrument has this phrase, I declare under penalty of perjury that the statements above are true to the best of my information, knowledge, and belief. And if we look at it, we will see that it certainly does say that. I declare under penalty of perjury that the statements above are true to the best of my information, knowledge, and belief. So if he signs it now, he doesn't need to go swear it before a magistrate. It's a complaint. Complaints must be sworn before magistrates. You're being convicted of a crime. If you're going to be convicted of a crime, somebody's got to swear to it. So hard to understand about that. So this guy's bullshit story about, well, this, initial dot surname is good enough is incorrect. I'm afraid I don't agree with that. I'm saying, okay, if you go ahead and sign it, you don't need to swear it because it has it on there. But let's say he is correct. Well, let's go on and let's just look a little bit deeper about what this said. It said, okay, that all this is for the purposes of section 1A to 1D of this chapter. Well, what is 1A to 1D had to do with anything? Well, first of all, 1, a complaint for an arrest warrant may be made under any electronic or electromagnetic means of communications if all the following occur. The prosecuting attorney authorizes the issuance of a warrant, authorization that consists of electronic or electromagnetic transmitted facsimile of the signed authorization. So he would have to send a signed authorization. A judge orally administers an oath or affirmation to the applicant of an arrest warrant who submits complaint under this subsection. The applicant signs the complaint. Proof that the applicant has signed the complaint may consist of an electronically or electromagnetically transmitted facsimile, in other words, a fax of the signed complaint, but it still has to be signed. And what does it need to be signed for? What's the complaint for? The whole thing, the whole reason for doing this, as we're going to see, is a magistrate shall issue a warrant upon presentation of a proper complaint. The whole reason for getting the signed complaint, this instrument here, because this is going to be the complaint. See, it says I personally served a copy of the complaint upon the defendant. This is the complaint. Its whole reason for being is so that the magistrate can issue a warrant. Okay? So the magistrate can, let's think about that. So the magistrate can issue a warrant. So whether or not we're going to say that the guy needs to sign it, or that the computer generated shit that comes out is good enough to be a signature, the whole reason for being of this instrument right here is so that they can issue a warrant. Where's the warrant? Where is the warrant? Warrant, rectification of an accusation, directions of the peace officer. More about the warrant. Issuing a warrant or endorsing complaint if accused in custody upon arrest without warrant, find a reasonable cause, endorsement as complaint and warrant. Where's the warrant? So, based on that, because I don't want to read all these, I mean, you can go read them yourself. The thing is, the complaint's to get the warrant. Where's the fucking warrant? You got a copy of the warrant? Nope. Well, then that's a warrantless arrest. That'd be an insurrection. So I wrote this for Sean. I said, well, Sean, here's my idea, right? Let's call it the Michigan One Court of Justice, because that's what it's supposed to be. Let's call it the District Court, because that's what it is. And then the division is whatever the judicial district is that he was in. This is the District Court Division of the Michigan One Court of Justice. It has an appeals court, a Supreme Court, a circuit court, a probate court, and a district court. district court division, whatever judicial district you're in. So, court administrator, as a follow-up to our conversation, Monday, February 3rd, 2014, approximately 1 p.m., in regards to ticket number, whatever the ticket is, I reviewed MCL 164E, complaint signed by peace officer, statement making material false statement in a complaint as perjury, penalty, contempt of court. I think you are mistaken in your explanation to me that the ticket having a computer-generated first initial surname for the officer is considered as an electronic signature, and that this section of the Michigan compiled law is the basis of your reasoning. All the section says is that if the officer signs the complaint, it is considered done so under oath, provided it is certified with the following phrase: I declare under penalty of perjury, the statements above true, best of my information and belief. Which this certainly does have those words on it. Those words are right here. And if this guy signs it now, he doesn't need to go swear it before a magistrate. It's considered done under oath. But again, this thing here is really just to generate an arrest warrant. And, they haven't given you one of those yet. By going further, in the instructions states that for the purpose of section 1A to 1D of this chapter, a complaint signed by a peace officer shall be treated as made under oath if the offense alleged in the complaint, yada, 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 yada. Looking at section 764.1a, we see that the sworn complaint for 764.1e is simply to allow for the issuance of an arrest warrant. A magistrate shall issue an arrest warrant presentation of proper complaint alleging the commission of the offense and finding reasonable cause to believe that the individual accused in the complaint committed the offense. The complaint shall be sworn before the magistrate or clerk. That's what 764.1a says, right? That he'll issue a warrant. Where is the warrant? You're going to court to pay a traffic ticket. Hell, you don't even have a warrant yet. In 764.1b, the magistrate authorizes arrest warrant shall be proper return noted on the warrant, and it shall be delivered to the magistrate. So when they go pick your ass up, they got to come back with the warrant, give it to the magistrate, and do a proper return. And that's where this return of service is, on the bottom of this arrest warrant. Return of service. I have executed this warrant by arresting the within named defendant on the day and time indicated below. They're supposed to fill it out. This one's not been filled out. Somebody was arrested on a warrantless arrest because this was not returned. So that's what they're supposed to do with you. They're supposed to get this complaint to get an arrest warrant so they can arrest you and take you before a magistrate and do a proper return of the warrant. 764.1b, without unnecessary delay before a magistrate of the judicial district in which the offense is charged to have been committed, to be dealt with according to law, and shall direct that the warrant with proper return noted on the warrant be delivered to the magistrate before whom the arrested person is to be taken. So they need to return the warrant to the magistrate that you're supposed to be taken in front of. Where's the warrant? 764.1c allows for the magistrate to endorse a warrant on the signed and sworn to complaint if the accused is in custody and the magistrate determines there is probable cause. And this is what they're going to try to get to happen to you when you go in the courtroom. All right, they're going to turn this into a warrant when you show up at court. All right, they're going to endorse this somehow. I don't know what's on the back side of these things. I don't know what else is on there, but what it's saying is they can endorse this and turn it into a complaint and a warrant. But it still hasn't been signed yet, so there can't be a warrant. 764 or 746-1c allows the magistrate to endorse a warrant on the signed and sworn to complaint if the accused is in custody, which you would be if you walked into the court building, and the magistrate determines there is probable cause. states that the substance of the accusation will be stated on the complaint, not just a fax. Not just a fax. I didn't spell that very well. Court Administrator, where is the arrest warrant? Based on the analysis given above, it is my belief that I am the victim of a simulated legal process and warrantless arrest. There is no signed complaint sworn to by certificate or before a magistrate, and no arrest warrant has issued, making this a warrantless arrest, possible insurrection, and treason against the state's constitution. You are to correct the record, expunge the charge, and see that my property is returned, including impound fees, bond payments, or I will send a complaint to the governor of the state about the obstruction of justice practiced by his subordinates. Because all these people are working under the executive branch. When you look at the organizational chart of Michigan, you got the judicial branch sitting off by itself on one side and the legislative branch sitting off by itself on the other side, not connected to anything. Everything flows through the governor. Because the legislative branch is to make the laws, and the judicial branch is to interpret the law, and the executive branch is to execute the law. And the law says they have to sign the fucking complaint. And I'm afraid you're wrong, Court Administrator, and if anybody knows a court administrator or a policeman, have them watch this. You guys are going to get your asses kicked. If you're not following the law, you're committing perjury. I know you didn't know it, but now you do. So what are you going to do tomorrow? There's no law broke if you don't know that the law is there. Well, now you do. This is saying in Michigan, if you don't sign this damn piece of paper here, and you take me to court thinking that you're just going to have your initial and name printed in here off of a computer and not have a warrant for my arrest, well, I'm going to take and put a complaint into the governor. I'm going to call it a plea of the crown. Or I'm going to go find me a conservator of the peace, and I'm going to accept his oath and bind it to it and give it to him. Because as we showed yesterday in Indiana, the conservators of the peace are the deputy coroners. And the coroner's main job in England was to be the keeper of the king's pleas and protector of his property. And the king's pleas are the king's orders. Right? This will not stand. So, that's in Michigan. State of Michigan, uniform law citation. Looks something like this. You may have seen one before. You get down to this part right here, complaint and signature or receipt if applicable. So let's say you've waited. See, here's the problem. Everybody waits until they're supposed to go to court, right? They don't go put an appearance in first, and then they don't put in a motion, because you can do motions into these cases. And you can put in an emergency motion to the judge saying, hey, there's no signature on the complaint, and I have not been served an arrest warrant. Where is the arrest warrant? Court? Because what they told this brother, now think about this. He already knows what day he's supposed to be to court, and he calls the court, and the court says, well, we don't have you in our system yet, but this is kind of how it works. Well, how can the court not have him in the system if he already knows what day he's supposed to be there? I thought this was all electronic and really quick and speedy and all spiffy and great. But they don't even have him in the system yet. Where's the arrest warrant? So if you waited till the day you went into court, they're going to want to have your, how do you plead, guilty or not guilty? I'm going to say, well, I demur, judge. I've not been issued an arrest warrant. Somebody is simulating a legal process, and there seems to be obstruction of justice. They've withholding the paperwork, the documents. Where's the arrest warrant? They return one to you yet, Judge? I thought that's what the complaint was for. I can read what the rules say. It says right here that after they do this, they don't need to swear to it, and now they can get an arrest warrant. That'll throw them for a loop. Let's look at this. Before we go into our next case, let's look at this arrest warrant real close again. What does it say on an arrest warrant? those of you who didn't watch last night's video, it says, to all peace officers in the state of Illinois, you are hereby commanded to arrest the defendant designated herein and bring said person, it won't let me quite have it as big as I want, without unnecessary delay before a judge of the circuit court for the 16th Judicial Circuit, Kane County, Illinois, in the courtroom and in the city and village designated herein, or if absent or unable to act, before the nearest or most accessible court in said county to answer a charge made against said person in violation of Illinois compiled statutes as set forth. You're hereby directed to hold said person to bail in the amount set forth herein. They didn't. So they came to Rose House and arrested her at her house without having the warrant with them. And then they took her to jail. Says you're going to jail unless you pay the bond charge. And they said defendant failed to appear. Failure to appear, warrant to issue. Well, if you read about failure to appear, at least in Arizona, it said if you fail to appear, then the clerk or somebody else in the court staff has to fill out a sworn complaint that you failed to appear and get an arrest warrant for failure to appear. But we look at who the complainant is, and the complainant is Sandy Wegman, who's put in this original complaint for disorderly conduct. So what they did is they activated an arrest warrant for something that happened back in August. They didn't activate or create an arrest warrant for failure to appear. All right, they were supposed to put in a complaint for failure to appear and get an arrest warrant. That's how it worked in Arizona. It was one of the videos I did on the traffic ticket in Arizona. Unfortunately, I don't have it in front of me right now. They didn't do that. But even more important, look at how they got Rose's name. Last name first, first name. They got her address. But this is not her zip code. 60175-0000 is not her zip code. Her zip code isn't in the 175. It's 60174 something or other, I do believe. They got two post offices in her town. 60175 is another post office. So this street address will never, ever, ever, 1903 Rita Avenue, St. Charles, Illinois, ever match up with this zip code. Yet here it is, right? This is computer generated stuff coming off of something. Well then, what's going on? Well, what they're doing, number one, is it looks like somebody's tampering with the mail because they've tied a zip code to an address that doesn't exist. But I think what they're doing is any time that it would print out on something, 60175-0000, right? That's a special mailbox someplace, and it doesn't really matter what anything else is on here. If the system reads this zip code on the envelope or whatever, it's going to send it to a certain box. I'm guessing. And so that's where the mail's going that you're not getting for the defendant. All right, here's the defendant. What mail hasn't Roe gotten? Because she didn't go do a proper appearance and so forth, right? Didn't go to the office of the clerk of the court and put in an appearance to say, hey, send the paperwork to me. So it's going to the defendant. Well, who's the defendant? Last name first, comma, first name. Anytime you go into court, look at a docket sheet. That's the way your name comes up. And by God, they're sending it to a zip code that has nothing to do with the street address. You tell me that isn't tampering with the mail. Now, you can't take a complaint like that to the Postal Service people. They ain't going to do a damn thing with it. But I certainly think you can take it to the postmaster and say, you send this to the Inspector General. If I have to do it, I'm going to add you to my fucking complaint. Excuse my French. So, there we go with that, right? So, this thing is messed up. There is no flood Betsy. There is a Elizabeth Flood, who's a judge, apparently. So we need to see, has she taken her proper oath and bond and so forth, and by what authority did they bring this charge? And it wasn't executed. This is an unexecuted warrant. It was a warrantless arrest. That's insurrection. Let's take it to the governor. All right, so now we got one more case to look at. This one's an interesting one also. Where are we with this thing? This is let's start although that's the proper page. Okay, this guy's driving down the road, and apparently, right, so again, how do they have him? Last name first, first and middle, as the defendant. You got a warning: unsafe lane movement on road within 3 or more. Anyways, he went over the fog line 4 times, is what they said. So they pulled him over, and then the cop comes up to the driver's window and he rolls down a little bit, and the cop says, "Can you roll down farther?" And he did, and the cop basically went in from the belly forward and is looking around inside the car. What are you looking for? Well, whatever. Then asking the guy questions and looking around some more and looking him in the face, asking him questions, and basically, right? All sorts of crazy stuff. So at the end of the day, what they did is they just gave him a warning for the stop, but then they charged him with something else because of the stop. And it says here, "I affirm under penalty of perjury as prescribed in some section that the foregoing representations are true." Officer's name, Meade, Nicholas. His name is last name first, first name. It's all strange stuff. So let's see if we can get this to fit here. So what they did is they filled out an arrest report. And so now the officer, get the arresting officer, but we have a witness, right? Witness, TRP, Ted Boner. Ted must have been a hell of a go through life. The Boner. Trooper Boner, arresting officer, Trooper Nicholas Meade. And that wasn't, they didn't have Trooper Nicholas Meade on the other paper. It was Meade, Nicholas. I always Trooper Nicholas Meade. On September, approximately sometime, traveling southbound or eastbound, yada yada yada, going over the fog lines, approaching vehicle, passenger side. When I approached the vehicle, the driver identified himself as, rolled down the window, asked how he may help me. As he would speak, I could hear his voice crack. Asked why I'd stopped. I explained to him I stopped him because he had to ask if he had been drinking or was tired. Well, thanks. Thanks for stopping. Thanks for your concern. He'd not been drinking. The whole time I was speaking about his violation. What violation? He was chewing on a piece of gum really fast. It seemed the longer the vehicle was speaking about the violation, the faster he would chew. Yada yada. So basically, what he did is he went and got his drug dog and decided to search the car, and he found 30 grams of pot, whatever that is, some little amount of hooter. Not hardly enough to make it worth your time. Cellophane wrapper full. So found some dope. And he gets down with this, and now he puts, "I affirm under the pains of penalty and perjury that the foregoing representation is true and correct." Trooper Nicholas Meade, and he signed it. So what we're going to find out is this statement here isn't good enough, because there's nothing on here from a notary. He didn't swear this before anybody. And like in Michigan, where I had the certificate that you can do and not have to go before a magistrate, it's got particular words you have to use, and this doesn't have it on there, so he didn't swear to this. But what I did want to show you was, before we get, it says on September 15th, 2013, and he swears to it. He picked a day certain. Okay, let's go look at the information they put in. These two counts: possession of marijuana, possession of paraphernalia. State of Indiana versus. Read this real close. The undersigned defendant swears that on or about the 15th. Well, he just swore to a day certain. Now it's on or about he swears to. And you'll find out you can't do that on an information or a indictment. It has to be a day certain. At the county of whatever, somebody, Craig C. Ladyman, did knowingly possess pure or adulterated marijuana, all of which is contrary to the form of some statute, contrary to the form of the statute in such cases made and provided, and against the peace and dignity of the state of Indiana. So forgetting that there's another charge similar to this, it says it's contrary to the form. It doesn't say anything about being contrary to law. It's contrary to form. Well, who fucking cares about your form? I don't care about your form. What, did I break a law or not? No. It didn't say I broke a law. It says whatever I did is against the peace and dignity of the state of Indiana. Now, that's important, because when we get to peace and dignity, what the hell does that mean? Against the peace and dignity of the state is a concluding phrase in an accusation of wrongdoing or indictment. It is usually used to condemn the offending conduct. The phrase is derived from the Latin term against the peace of the Lord the King. In ancient times it was used in indictments and civil actions of trespass. All indictments shall conclude against the peace and dignity of the state. In some other case, an information is fatally defective when it does not conclude against the peace and dignity of the state. The same is true with an indictment. So they're saying that it has to say that. Well, let's read more about this. The Queen's Peace, or also known as the King's Peace, is the term used in the Commonwealth realms to describe the protection of the monarch and the right of each state provides to his or her subject. In republics with common law traditions, the same is often referred to as the peace and dignity of the state. Maintenance of the Queen's peace is one of the duties of the Crown, carried out via royal prerogative. Through this power remains the Crown's through convention. It is exercised by the Queen and Council, that is, the executive, right? So this is a power exercised by the executive branch, or the sovereign acting in advice of his ministers to the Crown. The Crown can be held responsible should it fail in upholding the duty to maintain the peace. So this dude is driving down the road, went over the line 4 times, and they're saying that he's in breach of the peace. This was the justification for the Riot Act, subsequent legislation through the British Empire. When civil authorities had declared the Queen's peace as breached, i.e. there was a state of riot, right? There had to be a state of riot for the Queen's peace to be breached, and that's what they're saying that this dude did, is against the peace and dignity of the state of Indiana, that there's a riot going on. Then there was a change in the rules. The authorities, the police, army, militia, providing military aid, the civil power, could shoot and kill the leaders of the riot and generally take severe actions against anyone who was rioting. They're saying you're involved in a riot. The counterbalance was that the Crown was responsible for damage caused by the riot, having failed to fully preserve the peace. And to the present day, the criminal offense of rioting may only be prosecuted as such within the consent of the Attorney General. So a riot, or this thing about breach of the peace, has to come from the Attorney General. If disorder does occur but is not prosecuted as rioting, it is officially called a civil disturbance. as deeming it a riot transfers the liability of insurers from any damage or injury occurring from such an event to the local police, which, as they are officers of the Crown, make the Crown liable to pay. So the local police are officers of the Crown. Officers of the Queen's Peace have the right to detain persons who create breach of the peace. This is not a criminal or civil offense. It exists as a legal oddity created by royal prerogative. Okay? This thing about against the breach and dignity of the peace is not a criminal offense, but that's what this thing is for. It's saying that you're guilty of breaking some of a misdemeanor. Person so detained must be taken before a magistrate who will bind them over to keep the peace, or after the person may not disturb the peace again for the appointed time under threat of imprisonment. The police will frequently use the power to break up difficult situations, minor fights. Often the perpetrator may be detained only briefly until the officers are satisfied that the fight is over. This is what they're doing when they pull you over in frickin' for a court. Or for an indictment or a information. Remember, it's fatally flawed. Here's the important thing. If it doesn't say that, if you're in a IRS case and they have an indictment against you and it doesn't say, where the hell do they have that? All indictments shall conclude with against the peace and dignity of the state. According to this court case, the court observed that all indictments shall conclude with against the peace and dignity of the state. If it doesn't say that, then it's fatally flawed. You can point it out. Hey, it didn't say that I broke the peace. The police frequently use the power to break up difficult. They use it as a reason to pull you over, basically. Historically, and in particular before the founding of the police, the modern legal system, the Council of the Queen's Peace was much more important. Knights of the Peace were appointed in each shire, and it was their duty to maintain the Queen's peace. These Knights of the Peace later became known as Justices of the Peace, or JPs, or substantially as magistrates in the United Kingdom. Paid magistrates are now called district judges and are drawn from the ranks of local solicitors and barristers. Unpaid magistrates are volunteers from the community. The requirement that they must be a good character and a local residence. Influence in other legal systems. In the United States, arrest warrants and charging documents such as indictments are often constitutionally required to make reference to the offense having occurred against the peace and dignity of the respective state or commonwealth, that you were involved in a riot. In County Palatine areas of the United Kingdom, yada yada yada, there was nothing there. Information, an accusation or complaint made in writing to a court of competent jurisdiction, charging some person with a specific violation of a public law. Right? Well, they didn't say you broke the law. They said this guy, whatever he did, was contrary to form, but not contrary to law. It differs nothing from an indictment in its form and substance, except that it is filed at the discretion of the proper law officer of the government, ex officio, without the intervention and approval of a grand jury. So a grand jury does an indictment and a police officer does an information, and otherwise there isn't any difference. Informations have at their object to punish a crime or misdemeanor. Well, we just found out that this breach of the peace is not a crime or a misdemeanor. It is not a criminal or civil offense. It's just to give you a cooling off period. Take a time out before you breach the peace. Right? But the information is supposed to be to punish you for a crime or a misdemeanor. And they didn't say you committed a crime, you just said you're contrary to form, but not contrary to law. A summary proceeding before justice of the peace, the complaint or accusation, at least when the proceedings relate To penalty is called an information which is taken down in writing and sworn to. So, it has to be sworn to. Okay. Now let's go back to our example. As soon as I can figure out what the hell it is. I affirm under penalty of perjury, as specified in something that the foregoing representations are true and correct. Trooper something something. Doesn't have his name on here. Now let's look at some other interesting things. Here's a deputy prosecutor of the 34th Judicial Circuit, Elkhart County, state of Indiana. He's from the 34th Judicial Circuit. Then why is this court case being heard in the Elkhart Superior Court number 5? Right? Why isn't it being heard in the 34th Judicial Circuit? That's where this guy's a prosecutor at. That's his jurisdiction, the 34th Judicial Circuit. Doesn't say anything about having any authority in the Elkhart Superior Court number 5. That's one thing to point out. But there were some other ones. And what were they? What were they? Okay, so this was going through some of the laws of the criminal code of Illinois Criminal Code 3534. Indictment information. Commencement or prosecution, filing, sealing, violation. All prosecutions of crimes shall be brought in the name of the state of Indiana. Any crime may be charged by an indictment or information. Okay, this says the state of Indiana. It doesn't say in the name of the state of Indiana, and I think that that's what they mean. If you saw, it was all lowercase except for the word Indiana was proper case, capital I. All right, so this is a fictitious plaintiff here. This is actually a municipal corporation of some kind. Except as provided in some section, all provisions of crime shall be instituted by filing an information or indictment by the prosecuting attorney in a court with jurisdiction over the crime charged. So again, we don't know. This 34th Judicial Circuit attorney put it into the Elkhart Superior Court number 5 if that court has jurisdiction over the matter. And they didn't charge him for a crime. Again, they just say it's contrary to form, not contrary to law. And they're saying they breached the peace, and that breach of the peace was not considered a crime. Okay, so whenever an indictment or information is filed, the clerk of the court shall mark the date of filing on the instrument, record it in a record book, and, upon request, make a copy of it available to the defendant or his attorney. Well, I want a copy that shows it was recorded in the record book. I don't want just a copy like this. Now, this says it was filed, right? But was it recorded? I don't see anything on here that says it was recorded. I want to see that it was put in the record book of the clerk, because I don't believe it was. Contents requisites form. The indictment or information shall be in writing and allege the commission of an offense by stating the date of the offense with sufficient particularity to show the offense was committed within the period of limitation applicable to the offense. Right? So, was this done? Now remember, on here it says on or about the 15th of May. He's swearing to it. But over here, he swore it was on the 15th, not the 15th of May, 15th of September. Here he's swearing that's when it is, approximately sometime. And here he's swearing that it was on or about that day. Well, do you know what day you pulled the dude over? Cop? it gets even better. Still in that section, stating the name of every defendant, if known, and if not known by designation of defendant, yada yada. Indictment shall be signed by the foreman of a jury, the prosecuting attorney, or his deputy. The indictment, oh, that's an indictment. Well, we don't have an indictment. The information shall be signed by the prosecuting attorney or his deputy and sworn to and affirmed by him or another person. Okay, so I guess he signed it. Possibly this guy signed it, but who swore to it? Nobody swore to it. You don't see anything on here that they swore to it. There'd be something like this: signed and sworn before me, a notary public. That would be at the bottom. Not Illinois, it would be Indiana. I just pulled this one off because it was easy to find at the time. There's no jurat on it. It wasn't sworn to. An information shall be signed by the prosecuting attorney or his deputy and sworn to or affirmed by him or any other person. Where is the jurat that somebody swore to this? It's not on here. An indictment or information shall state upon the names of the material witnesses unless the names of witnesses stated in the indictment. Continuous. All right, so this doesn't have any witnesses on it. All right, this doesn't list any witnesses. However, on the police report, there is a witness. Ted Boner. Come on down, Ted. Got too many things open. All right, we can close that one. Let's continue on. The indictment may be substantially in the following form. Right? So if this was an indictment, it would say in the something, Court of Indiana, State of Indiana, give the date, versus somebody, give the case number. The grand jury of the county of, upon their oath or affirmation, do present that A.B. Okay. However, if it's an information, may be substantially the same form as the indictment, substituting the words the grand jury of the county of, upon their oath or affirmation, so present the following. CD, or the name of the cop, being duly sworn on his oath or having affirmed, says. Right? That's how an information is supposed to start. Not the undersigned defendant that on whatever, right? It's supposed to have his name in here. CD, right? So the cop, being duly sworn on his oath and having affirmed, says, then go on and say what he's going to say. Not the undersigned defendant. No, you got to put the guy's name here, and then he's going to sign it down here when it's all done. He's going to sign and swear to it on his oath. So it doesn't say that, so they didn't do it properly. It's incorrect. It is not necessary if an information states the reason for the proceeding rather than an indictment. Information should look like this. Right? CD, being duly sworn on his oath, having affirmed, says that on the blank day of blank month of some year at the county of the state of Indiana, and then the charge. Not on or about on a day. No, this way. Just like the grand jury would do it. On the blank day of the blank month of some year at the county of, not on or about some day. It has to be a day certain. CD's the name of the man being sworn. In other words, police officer. Date certain. For a crime. Not on or about. Page 2. The officer did not sign. Okay, a couple other things. Deputy prosecutor of the 34th Judicial District bringing a case to the Elkhart Superior Court number 5. So is it in the clerk's book? What else we got here? We almost done. Page 3 and 4 of the police report. List of witnesses, gives date certain, does not have the... Okay, page 4. Alright, page 4 of this police report. At the bottom here, I affirm under pains of penalty and perjury that the foregoing representations are true and correct. Does not have the correct words at the end to allow for it not to be sworn before a magistrate. Again, he would have to take this complaint before a magistrate because it doesn't have the right words on it. This one doesn't have the right certificate. Verified or sworn documents, form of oath, administration, false affirmation, or verification. If an indictment, information, pleading, motion, petition, probable cause, affidavit, or other document is required to be verified or sworn under oath before it is submitted to the court in a criminal action, the document meets the requirements of the law as sworn document if the following formula are substantially the similar. I swear affirm under penalty of perjury as specified by this section that the foregoing following representations are true. I swear and affirm. I swear under the pains and penalties of perjury. I swear under the penalty of perjury, as specified, that the following representations are true. See, this doesn't list this particular number in there, and this says has to be substantially similar to this. So you can't change this. It has to look like this. You can't put in a statement and not have listed the code number, because that's what the court wants. So unless it has that, then at the bottom there should have been something like this. Signed and sworn before me, a notary public on, right? That should be here at the bottom. Wasn't properly sworn to. He's saying he swore to it, but he didn't swear to it. Alright. What else was there? We're almost done here. May be done. Oh. Let's look at some of these things in this section of I canceled it. Interference with the general government operations. Perjury. Has knowingly made two or more material statements in a proceeding before a court or grand jury which are inconsistent to the degree that one of them is necessarily false. Well, in this one, he's swearing that if he had sworn properly that it was on September 15th. In this one, if he had sworn properly, it says it's on or about September 15th. Well, one of those is incorrect. Which one's incorrect? Which one's incorrect? One of them has to be incorrect. Well, that would be perjury. It's a Class D felony. Somebody just committed perjury. What else we got? Obstruction of justice. Withhold or unreasonable delay in producing any testimony, information, docket, or thing. Knowingly or intentionally induces by threat, coercion, or false statement a witness or informant in an official proceeding or investigation to withhold or unreasonable delay in proceeding a testimony or information, document, or thing. Where's the arrest warrant? Well, the reason there isn't an arrest warrant, he didn't break any laws. They're saying it was because of a breach of the peace. But they're going to charge him for these statutes, which all he did was contrary to form. It didn't say it was contrary to law, and it wasn't properly sworn to, and the form isn't correct, and so forth and so on. And, you know, there's all sorts of things that could be motioned to the court about. Which is the whole point of doing this whole thing, is we need to go put in our appearance and then motion for the proper thing. So Craig had already hired an attorney. He's got an attorney he's working with him. We're going to give him a list of things to do. Hopefully that's what Craig will do, and see what he does. Most people don't do anything. They call me and ask for my 2 cents worth. I give it to him. I don't hear from him again. We'll see what Craig does. What's this? Obstruction of justice, right? Unable, withhold, or unreasonable delay in producing any testimony, information, document, or thing. Where's the arrest warrant? Where's the charges under oath? Alters, damages, or removes any record, document, or thing with the intent to prevent it from being produced as evidence in an official proceeding or investigation. We'll have to see if they do that. They try to remove it from the record. False reporting. A person who gives a false report of the commission of a crime or gives false information in an official investigation of the commission of a crime, knowing the report or information to be false. That's what the cop did. It's a false report. He's charging Craig with a riot for driving down the road and going over the white line a couple times. And somebody's assisting a criminal. A person not standing in relation to a parent, child, or spouse to another person who has committed a crime or is a fugitive from justice, who, with the intent to hinder the apprehension and the punishment of the other person, harbors, conceals, or otherwise assists the person, yada, yada, yada. Right? If you conceal, you're assisting a criminal. You conceal the truth, you're assisting a criminal. Impersonation of a public servant. See, we don't know if this cop has taken the proper oath to hold the office that he says he holds, or the prosecutor for that matter. By what authority did they bring this charge? I want to know if they took the constitutional oath. In Michigan, it quite clearly says in the Constitution what oath they're supposed to take. Have they taken it? A person who falsely represents that a person is a public servant with the intent to mislead and induce another person to submit to a false official authority. Such as, it's a Class D felony to impersonate a law enforcement officer. It's unlawful to use a police radio or to possess a police radio unless you're a policeman, right? Did they take the proper oath? Again, they told Rod Class that all the policemen in North Carolina are private contractors. Well, did that private contractor take the proper oath to be a peace officer, or is he a police officer? Is he working for Walmart, or is he working for the state? And I showed that judge's oath from Illinois, where it shows that the office that would say that he was on the state payroll hadn't signed off on it yet. So he's not a state employee. It was missing a signature. It's like everything else. They go so far with the paperwork and then they stop. Right? Everything is unexecuted. So, anyways, I don't think that there's a thing in here that this guy did wrong. If you can be contrary to form, well, I've screwed up a lot of forms in my life. But that ain't what they're getting him for. They're getting him for riot against the peace and dignity of the state of California, or Indiana. They're claiming the king's peace, saying you broke it. You need to claim the king's peace and say, whoa, 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 how is it that I am guilty of a riot? Are you saying that contrary to form is the same as contrary to law? Swear to it. You haven't sworn to your complaint. And all the other things we pointed out today. And all sorts of stuff. So, let's leave it there. Just some more things about, going down the road. Road trip blues. They're going to try to get you for something. You got to be ready to put in your appearance. Possibly a motion to see their last. And remember, if you can donate, I can use it. AshleyRutluski@gmail.com, or just mail it to Robert Rutluski, 10955 14 Mile Road, Rockford, Michigan 49341. And I forgot to say it again, Handcuff John, thank you, thank you, thank you. You came through when I really needed it again. Thank you very much. We'll talk to you all soon. See ya.